Hi, my name is Chris Dysart of the Dysart Law Firm. The owners of gas pipelines are not always the same companies that supply the gas. These companies may also contract with others to provide maintenance of pipelines. Additionally, natural gas lines may rupture as the result of actions by others, such as construction excavation companies. As a natural gas explosion injury lawyer, in order to determine liability, it is important to identify all those who may have constructed, owned, or been involved in the operation or maintenance of the gas pipelines, or who may have caused a pipeline to rupture. Often, there are multiple parties that are at fault. Many gas explosions are caused by unsafe conditions that could have been prevented. Failures to perform routine maintenance and adhere to health and safety codes, and failures to fix known potential hazards are some of the most common causes of gas explosions. In these situations, negligent gas companies, pipeline owners, or construction companies can and should be held liable for compensating victims. As an example, a construction company may have ruptured a pipeline during the course of excavation, causing an explosion and fire. Additionally, the manufacturers of the pipeline may not have built the pipeline to proper specifications, which may have resulted in an increased risk of rupture. The pipeline may not have been installed correctly, or the pipeline owner may not have properly performed required maintenance, or the maintenance may not have been performed correctly. Our firm is dedicated to uncovering the truth so that we may hold all those responsible for their share of the liability. There are typically three main types of natural gas explosion cases. The first, cases in which either a construction company failed to assess the location of a gas pipeline before digging, despite specific OSHA guidelines requiring that all underground installations be located before excavation, or the gas company gave the construction company inaccurate information. Two, cases in which a natural gas pipeline failed as a result of a corroded or cracked pipeline due to its age and exposure to water, mud, and other contaminants, creating a natural gas leak. The third type of case involves new building construction, where the new pipes end up absorbing the odorant added to the normally odorless and colorless natural gas in a process called odor fade. In all three of these types of lawsuits, the liability falls on either the construction company, the gas company, or the building contractor. Explosion lawsuits are some of the most difficult cases to litigate and prove at trial because of one simple fact. Key evidence has very likely been destroyed, and sometimes the key witnesses have also died in the blast. Obviously, the fact that there was an explosion anywhere is enough to suggest negligence, because it means that someone did something unsafe. But that isn't enough under the law to prove that a particular gas company, product manufacturer, construction company, or contractor is liable. Legally, the injured person or their survivors bears the burden of proving that the explosion was the result of the defendant's negligence. Proving those facts requires a law firm that can thoroughly investigate the facts, hire the right experts, and develop the effective legal theories that will win a trial. If we are hired by you in a case, we will respond immediately and begin to investigate the origin and cause of the fire. We are prepared to aggressively represent individuals and their family members who have been injured by gas explosions. Time is critical in gas and fire explosion cases. It is important to have an experienced attorney and their team of fire investigators and experts on the scene as soon as possible. I want to emphasize to you, it is critical to take action now. To preserve the evidence you will need to win your case. Call the Dysart Law Firm today, toll free at 888-586-7041. That's 888-586-7041 to begin the path to legal recovery.